afternoon, everybody. This is Bonnie Vandermeulen, Training Coordinator for Wisconsin Facets. On behalf of our entire Wisconsin Facets staff, I'd like to thank you for joining us today. Today's webinar is entitled Wisconsin's Law on the Use of Seclusion and Physical Restraints in Schools. Today's presenter is Marge Restraint. Marge is the School Administration Consultant for the Wisconsin Department of Public Instruction. Marge has worked for the department since 2007. Her work focuses on special education legal compliance issues. She is the lead consultant for the state IDEA complaint process. Marge was a special education teacher in the Madison Metropolitan School District for several years, where she taught many students with disabilities in the classroom, community, and vocational settings. She holds a law degree from the University of Wisconsin and has worked as an attorney in the areas of disability and elder law. It gives me great pleasure today to introduce you to Marge Restraint. Marge?
Thank you so much, Bonnie. It is great to talk with all of you today about a topic that is so important and always good to get a refresher on for sure. So I appreciate you all taking some time today to have this presentation and to spend some time with me on this. As Bonnie mentioned, today I'm going to talk about the law on the use of seclusion and physical restraint. I'm going to talk about what the law requires and just a few other little things about changes to the law that have happened in recent years. But at this point, I will say that I don't really consider this to be the new law anymore. It's just the law. So it's something that's been around for a while. And again, districts should know, and parents, you also should learn about it so that you're aware should you encounter anything to do with it. So first of all, the law on seclusion and restraint in schools is located in section 118.305 of the Wisconsin statutes. And that's not super important to remember, just to know that it is indeed a state law. So this is not suggestions or just guidance. This is the law that needs to be followed. You will hear sometimes people refer to the law as either Act 125 or Act 118, and those were two different pieces of legislation that put the law in place. So prior to 2012, Wisconsin did not have a law regulating the use of seclusion or restraint in public schools. There were laws about other types of facilities, and other states perhaps had those laws. We didn't have one in Wisconsin. So it was enacted and signed by Governor Walker in 2012, and then modified in 2019 based on Wisconsin Act 118. So when you hear people say Wisconsin Act 125 or 118, they're really just talking about section 118.305. So that's that. The main thing, the big takeaway that is really the thing to walk away with, and all the rest really, there's a lot of detail around it, but the main thing to remember is that in Wisconsin, the use of seclusion or physical restraint is prohibited unless a student's behavior presents a clear, present, and imminent risk to the physical safety of the student or others, and it is the least restrictive intervention feasible. Again, the main point of this law is that it is a prohibition against the use of seclusion or physical restraint, except for in those very rare circumstances when a student's behavior presents at clear, present, and imminent risk to the physical safety of the student or to others. And a couple of things just to note about that. We are talking about the physical safety of the student or others. So this can create some tough situations for schools sometimes, in that there may be things like property damage occurring, there may be other things like that occurring, but until someone's physical safety is at risk, it's really not okay to use seclusion or physical restraint. It has to be the least restrictive intervention feasible. Another way to think of it is that it's a restriction or it's an intervention of last resort. So really we're talking about very rare, we're talking about crisis situations, and there's really no option. And the duration of any seclusion or restraint has to be extremely short, limited to the time that's necessary to resolve the imminent risk. So once the risk is passed, the student should no longer be physically restrained or in seclusion. Another important thing to remember about this law is that it applies to all students. Now, primarily today, I'll talk a lot about students with disabilities, and that's a lot of the context in which seclusion and restraint gets used is happens to be with students with disabilities, and there's a lot of reasons why and questions that arise given that. However, it does apply to all students. So this law applies the same if there's a fight in the cafeteria or at recess or something like that. I mean, this is the same law that governs the actions of staff in any of those circumstances. So it's not only for students with IEPs or 504 plans, this is for all students. Seclusion is defined as involuntary confinement of a student apart from other students in a room or area in which the student is physically prevented from leaving. We come back to these definitions all the time when we get questions or complaints around the use of seclusion and restraint. Is a circumstance seclusion or is it not? If it's not seclusion, then what is it, right? There's lots of things that we do in education that might keep students apart from other students. So for example, a student might get sent to the hallway if they're having a hard time, or maybe kept in for recess or something like that. Those things aren't seclusion. Seclusion is a very specific situation in which the student is involuntarily confined apart from other students, and this is the big one, in a room or area from which the student is physically prevented from leaving. If the student isn't physically prevented from leaving, it's not seclusion. It may be something else. It may be something that is or isn't a good idea, but it's not seclusion if the student is not physically prevented from leaving. And that's really important to remember because there are times, if it is seclusion, there are some very specific requirements that apply to the spaces in the rooms that can be used for seclusion. So let me get into a little of that for you. First of all, we're going to talk about the definition of physical restraint. So physical restraint is a restriction that immobilizes or reduces the ability of a student to freely move their torso, arms, legs, or head. So it's really about physically restraining, and it is a physical restriction. It's not a mechanical restriction. We don't allow mechanical restraints in the state of Wisconsin. So that means no items can be used by school staff in controlling the movement or restricting the movement of students. We also don't do chemical restraint in the state of Wisconsin. That is that educators aren't allowed to use medications or something like that to restrict the movement of a student. So we're talking about physical kind of intervention, a restriction that immobilizes or reduces the student's ability to move their head, torso, arms, or legs freely. These requirements, the law apply to all public schools. So that's public schools in regular school districts, that's independent charter schools. It applies to private schools that participate in the special needs scholarship program. So those are schools that, as a kind of a condition to participate in that program, they know that this law applies to them and that they need to pay attention to it. And it also applies to private schools when a student is placed there by a public school district. So there are situations in which a student's needs are such that an IEP team determines that a placement in a location other than the public school is necessary. And sometimes that includes private schools. Some examples that we hear in Wisconsin are like the Richardson School or oh gosh, I'm blanking on the other names, but there's several different private schools that serve students with disabilities. And so there are on occasion times when a school district will place a student at that school district's expense at that school. And when that happens, this law is definitely applicable. One of the things that's was a change to the law is that it didn't used to have a definition for the term incidents. So we'd be talking about incidents of seclusion or incidents of restraint without knowing exactly what we meant or exactly what the law kind of thought it meant. So what was changed is that now incident is defined as an occurrence of a covered individual. So that's generally a school person or a law enforcement officer. And we're going to come back to law enforcement officers a few times during this presentation, but just for now, know that an incident is either a covered individual, which you can kind of interpret as a school staff person, or a law enforcement officer using seclusion or physical restraint with a student. It is considered one incident if immediately following the use of seclusion or restraint, the student's behavior presents a clear, present, and imminent risk again, and then that school staff person or law enforcement officer resumes the use of seclusion or restraint. So we would get questions about, well, okay, if the student was in seclusion and the behavior was changed, and so the behavior no longer presented that risk, the student was out of seclusion, but then the behavior escalated right away again and they needed to go back into seclusion or use physical restraint. Is that one incident? Yeah, we would describe that as one incident. However, we would really want it to be very clear in the documentation and reporting of that incident what happened all along the way. So you'll see how that kind of ends up playing out. But what that means is that for documentation and reporting purposes, that is one incident. It might have a few different uses of seclusion or restraint during that incident. So previously, prior to 2019, the law didn't clearly apply the reporting requirements, the notification requirements, didn't clearly apply to when law enforcement officials are in schools and use seclusion or physical restraint on a student. And most often when this comes up, we're talking about physical restraint. And a lot of times when this comes up, we're talking about law enforcement officials acting in a law enforcement capacity, using handcuffs or doing something that is allowable under their rules for seclusion and restraint. So law enforcement officers in schools, they still are law enforcement officers. So they have their own set of training and requirements when it comes to how they utilize kind of physical interventions with people generally. A law enforcement officer, many of these, the requirements of the law, they apply not to law enforcement officers in terms of their practice, but what definitely does apply is that schools need to report the use of seclusion or physical restraint by law enforcement officers when that happens in a school. So that responsibility falls on schools to make sure that if a law enforcement officer uses seclusion or restraint on a student, even if that restraint is handcuffs or something like that, that maybe that's acceptable in their capacity as a law enforcement officer, but would not be acceptable in our capacity as school officials, that still needs to be reported. So it's really, there shouldn't be a question about that. Parents should be notified by school of these incidents, and the schools are required to report them and document them. You'll hear a lot of what I'm saying applying to students with IEPs, remembering what I said before, that the law applies to all students. There are portions of the law that are specifically applicable to students who have IEPs. So these are students with disabilities under IDEA who have IEPs. Students under Section 504, while they're certainly covered under the law, the IEP requirements don't apply. So it used to be that if an IEP team of a student with a disability determined that use of seclusion or physical restraint might happen, if it was reasonable to think it could be anticipated, the IEP was required to actually contain the terms seclusion or physical restraint. So there was a lot of discussion about when that was required, when it wasn't required, but basically the idea was if it was going to be reasonably anticipated, it needed to be noted in the IEP. That's not the case anymore. Act 118 repealed that provision of the law. So now IEPs are not required to include those terms. We still occasionally see them. It's not to say that they're not allowed to use those terms, but it's not a requirement. And I think the idea being that when it was included in IEPs, it sort of almost felt like, oh, this is part of the plan. This is an intervention we plan on using. And I don't think that ever should have been the case. Really, this is always about crisis intervention, rare, last resort kind of an intervention. So, planning to use something that really is a last resort is kind of that's sort of tough. I mean, that's I think part of the reason why the legislature made the decision to take that requirement out of IEPs. So again, it's important that parents are informed when this does happen, but it doesn't need to be in an IEP as part of a plan. And I would say in many cases it would not be appropriate for it to be in an IEP as part of a plan. IEP teams have to meet after the second incident of seclusion or physical restraint in a school year. So if there are 2 incidents after the second, the IEP team has to meet to review the IEP within 10 school days of the incident. That only means the second incident. So incident 1, incident 2, meeting. It doesn't mean incident 1, incident 2, meeting, incident 3, incident 4, meeting. That's not what it means. What's required by the law is that the IEP team meet after the second incident in a school year. Now, does that mean the IEP team can't meet more often, or should it meet more often if seclusion and restraint is an issue for a student? I would say, heck no, it doesn't mean that. Absolutely. IEP teams should meet a lot when you've got a student whose behavior is challenging to the extent that crisis intervention is necessary. That means that there's a lot going on there and that it is appropriate for that IEP team to be reviewing the IEP and the efficacy of their interventions on a pretty regular basis. What this just is kind of the minimum. The bottom minimum line is that if a student with an IEP has seclusion used on them once and then twice, it's necessary to get that IEP team together to take a look at the IEP. And what the IEP team needs to do is to make sure that that IEP includes appropriate positive behavior interventions and supports. So that's a requirement anytime a student's behavior impacts their learning or the learning of others. But it also, these positive interventions and supports must be based on a functional behavioral assessment, or an FBA, of the behaviors of concerns. FBA is a process in which teams get together to talk about data, observations, other sources of information to try to figure out why a behavior is happening. What is the function of that behavior? What is that what is that doing for the student? And then do we need to teach some replacement behaviors? Do we need to alter something about the environment or maybe the way we're dealing with the student? There's lots of things that can change when you have a good FBA to figure out the function of behaviors. And I could talk about FBAs for a full webinar on their own, and not to mention probably a full day presentation. So I won't belabor it at this point, but what I will say is that to me, one of the most crucial things about any behavior and understanding is a good functional behavioral assessment. And so really important that the IEP team look to make sure that the interventions that they have in an IEP are effective. And they're going to be most effective when we understand what they're about. And that's why the FBA is required for this particular component of the law. Here's some very specific things about seclusion. Before I was kind of talking about when something is seclusion, when something isn't seclusion. It gets really, really important partially because of these specific requirements. So it used to be that the doors to the room or area used for seclusion could not be capable of being locked. So, there might have been locks on the doors, but they were disabled, or, there might have been the possibility, but it wasn't happening, again, usually because they were disabled. Under the current law, and so the law that applies now, it is very clear that no locks are allowed on the rooms or areas being used for seclusion. So no locks on those doors. Even if that lock is disabled, even if that lock, doesn't work and hasn't worked in years, we don't have locks on, we can't have locks on rooms that are used for seclusion. So there was a situation that we dealt with relatively recently where a seclusion space had a mechanism on a door that was a disabled lock. I mean, you couldn't lock it, but had been a hole in the door because it was previously a lockable door for uses of the room, in the past. And when they took that out, well, then there's this hole in the door. Well, they put kind of this disabled kind of lock back in to sort of plug the hole. And that really wasn't okay, because even just having it there gives the impression that it could be locked. And you never know. I mean, we don't want to have locks on the doors. The legislature made that decision for us. So anything that is a lock is not allowed on a door of a room being used for seclusion. Something that hasn't changed is that when a student is in seclusion, staff must maintain constant supervision of the student. Constant visual supervision means that they can see the student at all times during the period of seclusion, in all parts of the room during the period of seclusion, and the room has to be free of objects or fixtures that may cause injury to the student. So what this ends up meaning sometimes, so first of all, let me go back to the supervision. Um, what's necessary is that if there is a room where seclusion is being used, there needs to be a window in the door that is large enough for the people in the outside of the room, standing outside, to see what's going on in every corner of that door. Um, that can be accomplished through the use of like fishbowl mirrors and things like that to make it so that an otherwise not visible part of the room is visible. But it's crucial, crucial, crucial that someone is maintaining that visual monitoring supervision of that student the entire time they're in seclusion. Entire time is the entire time. We don't want people kind of chatting, walking away, that sort of thing. That's not what we want. It's constant supervision is what the law requires. And the room must be free of objects or fixtures that may cause injury. So what does that mean? Well, it means that many, many, many rooms in schools, the majority of rooms in schools, aren't going to be appropriate places for seclusion. What we mean by that is a principal's office an appropriate place for seclusion? Nope. Principal's offices have desks, have pens, have window, there's stuff in those rooms that a student could injure themselves on. So it's not okay to send a kid to the principal's office, close the door, and be on the other side of the door and prevent the student from leaving. Are classrooms safe places to seclude students? And generally, in fact, I wouldn't even say generally, my answer to that question is no. Classrooms have desks, they have pencils, they have computers, they have all kinds of items in them that could cause injury to a student whose behavior was escalated. So we hear sometimes of a circumstance where a student's behavior is escalating and the staff decide that what they're going to do is remove the other students from the room so that the student whose behavior is escalating remains. That can be an okay kind of an intervention, but what can't happen in that circumstance is that the student is isolated in the room with the door closed and that student is physically prevented from leaving. And the reason for that is because all of the items that are in the classroom would make it an unsafe place for seclusion. So it may happen that staff clear a classroom of other students and they work with the student on de-escalation, or maybe it's a time to intervene, or just quiet the room down, something like that. That can be a reasonable thing, but that's not seclusion. And if the use of a classroom kind of turns into seclusion, that's not okay because of the items in the classroom. That can be a real tricky one, I know, for folks in schools. And sometimes that the idea of removing other students from a classroom when another student is escalated can really be effective in de-escalating the situation, or just for the safety of the other students. So I know that gets used, but again, is that seclusion only if the student is physically prevented from leaving the room? And is it okay to seclude a child in a classroom? Odds are really high not. I will never say never, but hurt near never. I can't imagine a circumstance in which a classroom wouldn't have some objects or fixtures that could cause a student injury. A few things about restraint that are clearly prohibited now. Always in the laws, as long as we've had it in Wisconsin, we've basically said that any kind of a maneuver that doesn't protect a child's head, that causes chest compression, that causes weight on an artery, neck, throat, back of a student's head or neck, that anything that would obstruct the student's circulation or breathing have always been prohibited. We have always interpreted that to mean that face down maneuvers by definition are going to do at least some of those things. So prone or face down maneuvers have never really been allowed, but now the current law says very clearly, calls out specifically that prone restraints are not allowed. So still not allowed to do any type of maneuver that causes any of those things, but prone restraints specifically are prohibited. I think they never were allowed, but now the law is super duper clear. There are no face down physical restraint maneuvers allowed. And you know, that's for a real seemingly obvious reason, and that's that those types of maneuvers carry a very, very high risk of injury and often death to, or not often, but on occasion, death to people who are restrained that way. And there's restrictions in all kinds of settings on those kinds of maneuvers because of the risk of death of injury or death that they involve. So it makes sense that they would not be allowed to be used by school staff in schools. Something else that was clarified is that vehicle safety restraints for students, so in other words, whether it's a car seat, whether it's seat belts, or whether it's some sort of a harness, if they are appropriate for the use of a student when they're in transport, that's not considered a mechanical restraint. So two things: appropriate use of that restraint, used as they're intended, and only when the student is in transport. That's not a mechanical restraint. So in other words, it's okay to use a harness while a student is on transportation or on a bus for safety reasons. It's not okay to use that same harness on the student in school to, keep them in their seat. That would be mechanical restraint. But that same harness in the context of a motor vehicle is okay to be used. It is really important that when a student requires some sort of safety restraint or equipment that goes beyond that which is available to all students, or is provided. So I mean, again, I don't know, it's been a while since I've been on a school bus, so I don't know about seatbelts on a school bus, but if a van has seatbelts, if there's more than that, it's really important that that get documented in the student's IEP so everybody's on the same page about the use and the importance of that that device or equipment for a student. And again, chemical and mechanical restraints, as I talked about before, never allowed. So again, that same type of restraint that's okay in a moving vehicle isn't okay outside of that context. That isn't to say that students who use wheelchairs or other types of equipment that is prescribed by medical personnel, that is used for their safe ambulation or postural support or things like that, those aren't considered mechanical restraints either. But again, it's really important that if you've got a student who needs to use a wheelchair, that everybody understands how that safely operates and what the equipment, how that needs to be used. Again, if it's prescribed by and used in under the conditions that are medically approved, that's different. That's not a mechanical restraint. But again, that has to be well understood and really documented as something that the student needs for that postural or movement support or something like that. This is something that didn't exist in the previous version of the law, and this is a really, really, really important one. And I think if anything is going to really make a difference about the use in seclusion and restraint, it's this. After each incident of seclusion and restraint now, the principal or whoever the principal designate has to meet with the people who were there, the people who were involved, to talk about the incident. So we're talking about what happened preceding the incident, what happened during the incident, what happened following the incident. What was the student doing? What were the staff doing? What might have been some triggers? What, all of these things. And equally as important is talking about what um, what how potential ways to prevent the need for seclusion and restraint. So what could have been done to de-escalate the student? What might we have done to contribute to the escalation of the student's behaviors? And what might we be doing, what should we be doing differently should this happen again? And this debrief is not an IEP team meeting. Again, the only time an IEP team meeting is required is after the second use of seclusion or restraint. So this could just be a meeting after school with the folks who were there. And, again, it doesn't have to be a formal IEP team meeting. However, really important, I think, to have these discussions. It's supportive of doing things differently for the student next time. It's supportive of the needs of staff because, when you're in an incident like this or when you're involved in it, even if you're super well trained, it's really difficult and traumatic for everybody involved. I mean, least of all the student, but it's not easy on staff either. So these debriefs are really, really important. And now the law very clearly requires that. And so in many situations, you'll see on reporting forms, we'll talk more about that in just a smidge, but on the reporting forms, you'll see a place for whoever's completing that form to mention whether the debrief meeting occurred and who was there and what was discussed, that sort of thing. So that's a requirement now. Parents always need to be notified of an incident of seclusion or restraint as soon as possible, but definitely no later than 1 business day. So that can be by phone, that can be by text, that can be in person, however it works. But the principal or the person the principal designates needs to make sure the student is notified immediately when there's been an incident. This is one of the things that prior to the law, I think was the most problematic. When seclusion and restraint is going on and parents don't know about it, it's just completely unacceptable and really caused a lot of difficulty amongst parents and schools in certain situations. So, and I can understand that very much. And I think anybody can, if you think about it, that you would need to know if this happened. And so it needs to happen as soon as possible and no later than 1 business day. If it happens on 4:30 at a Friday afternoon, make sure they know by Monday at 4:30. But again, I think the best practice is to let the parent know right away, immediately. And different than what it used to be is that this requirement also applies when an incident occurs involving law enforcement officers. So a principal may not be able to say, well, a law enforcement officer can't do this or can do this in the school. That's not what this means. What this means is if a law enforcement officer is involved in an incident of seclusion or restraint in school, that the principal has to notify the parent of that incident. There may be other notification from law enforcement. There may be, things like that that are part of their processes and procedures, but it's super important to know that the school needs to be sure to notify parents when that happens. So again, this is just the notification. This is just, hey, I have to let you know. This isn't the documentation. The documentation comes next. The documentation of each incident, principal or the person the principal designates has to consult with the people who were involved. And if that includes law enforcement officers, consult with them. They have to talk to them and consult before they complete the written report. The report has to include the student's name. The report has to include the date, time, duration, and the use of seclusion or physical restraint. Has to include a good description of the incident, including of what was going on before, during, and after. And the law says it this way: a description of the actions of the student before, during, and after the incident. But I think it's also important for us to think about and possibly document what were the actions of staff, what were the adults doing before this happened, because again, it's just really all a very important information, and it's not to be blaming or to be anything like that. It's not to, assign any kind of fault for this. But what's really important is when something like this happens, it's a big deal. And we need to be sure that we're being reflective and thinking about how to avoid another circumstance like this in the future. So while what the law says specifically is a description of the actions of the student, the kind of context in which it happened, including what were the adults up to, is a really important part of the documentation as well. The names and the titles of the folks who are involved, so that's both the school staff and any law enforcement officers present, need to be included in the report. So the principal must keep that report, and they have to give it to the parent. They have to provide it to the parent within 3 business days of the incident. The method of providing it to the parent can be, determined. Some parents would like emails, some parents would like things to be delivered in person, whatever, however it works out. But the principal has to make sure that it gets sent to the parent within 3 business days of the incident. Used to be that, you'd have to let the parent know it was there and the parent could ask for it, all that sort of thing. When the law changed, they just eliminated that. Please make sure that you're letting parents know when this happens, both informing them immediately and then also that they get a copy of the report. There should never be questions about whether parents are getting copies of the report. You need to provide them. Okay, so training requirements. Except in very, very limited circumstances that really are kind of emergency circumstances, school staff are not allowed to use physical restraint unless they've received training that covers all these things on the page. And I mean, I'm not going to read through all of them, but you can see that that training has to include instruction on positive behavior supports, things like de-escalation, how to safely escort a student, conflict management, those sorts of things. Evidence-based techniques around debriefing that will help to reduce the use of restraint. In all cases, we're looking to eliminate or reduce the use of these techniques. They're not to be used. I mean, again, going back to the first slide, it's a prohibition on this only if. And so again, training around ways to avoid it really makes a lot of sense. Then instruction and understanding and describing behaviors that could indicate the need for restraint. I think sometimes there are circumstances where a student's behavior is escalating, but is this or isn't this a risk to the physical safety of the student or to others? The staff have to make calls on that sort of thing really fast and really, quickly in the moment. But it's really important for folks to be trained to recognize when when that's accurate and when it's not. So again, effects of restraint on the people being restrained. I mean, again, that all makes great sense. And whoops, oh goodness, here I go going crazy with there we go. And a demonstration to apply to identify prohibited restraint techniques. So again, these training requirements are pretty well known by most of, well, I think by all of the kind of bigger providers of training in the state. There's, I don't know, there's a few different ones. There's CPI, there's PROACT, there's a few of them. Different CISAs who are trained in those different different types of programs a lot of them have trained the trainer programs, and so folks at either the CISA or school district level will get trained, and then they're able to provide that training to their staff. And again, the important thing is that unless there is a really emergency that is not foreseen at all, nobody ought to be using seclusion or physical restraint, particularly physical restraint, if they haven't been trained to do so safely. So that can, again, there are emergency situations that come up, but overall, we need to make sure folks are trained. And schools have a responsibility to be sure that that training is kept up to date for those folks. 1/2 day of training doesn't mean that in 10 years you're going to remember exactly how to do this. Every training program has requirements about how often they need to have refreshers, or how long it's good for. There's documentation about how long and when folks were trained. Schools need to maintain that documentation. So again, really important to make sure the training includes everything that's required, and that then the school is keeping up on the training requirements to make sure folks are up to date and trained in and refreshed enough so that, should this ever come up, someone's able to do the right thing and to rely on that training. So every school year, every school needs to gather up all of the incidents that were reported or that happened in their school district, or in that, let me say that again. Each school is responsible for their own their school's information, compiling it and making sure that it gets submitted to the governing body, which in most cases for public schools is a school board. Sometimes if it's a public charter school or something, it might be a nonprofit or something like that. But for folks who attend, regular school district run schools, each school needs to make sure that they submit the following to the school board every year. So by school, the number of incidents of seclusion, number of incidents of students who were involved, the number of students with disabilities who were involved, the number of incidents of physical restraint, the number of students who were involved, and the number of those students who are students with disabilities. So this, again, every school needs to report this to their school board, and now it's by every year by October 1st. It used to be September, but this gives the districts a little more time, again, to compile this from the previous school year. So right now, or last month, October 1st, folks were gathering information from the 21-22 school year and reporting it to their school boards. And oops, there I go again. And by December 1st, each of those districts has to submit a report that's disaggregated by school. That same data that was just talked about as being reported to the school board needs to be provided to DPI. And the way that that happens is every school district gets sent a link to a survey that's used to report the data for every school in their district. And we've done it now. This will be the third year we've collected the data. It's been interesting because, again, no new data collection comes without little glitches here and there, but the data is really important, and it's been something that we've learned some things from. The timing was a little weird. The changes in the law went into effect in March of 2019. And something else happened in March of 2019 that had us all a little busy and thrown off, and that was the start of the pandemic, right? So we've had 2 years of data that have come in, but they've been based on school years that have looked a little different in many cases. So while we've got 2 years of data, it's not really data that is super reliable in terms of helping us see the trends of schools over time. So, it's just the nature of the way things were during the pandemic. Now, though, we've got a full year of school in-person school in most cases for the 21-22 school year that we're going to be receiving December 1st. And I know that districts are in the process of compiling and submitting that information now. So the data from the previous 2 years is already available on our website. The 21-22 data will be available soon. And also available on the website is a really good summary of the data. It's the folks who do this just do a really great job of kind of talking through the data and what have we learned from this data? What is this data showing us? What are we seeing here? And what do we need to do differently to, when we need to change the way things are happening? And I just wanted to talk a little bit about some of the lessons that we've learned from the data. And I expect that we'll continue to learn more lessons from the data as we get more complete data from a full in-person school year. The lessons really are that despite the fact that the prohibition applies to all students, the vast, vast, vast majority of incidents of seclusion or physical restraint continue to involve students with disabilities. And this is students with IEPs. I mean, this is defined as students with IEPs, not students with 504 plans, but the vast majority of these incidents involve kids with disabilities. So that's something we need to really think hard about. Why is that happening? What's the reason for that? And I think in every school, in every situation, with every student, there are different things that IEP teams and school staff need to consider to think that through. Why is that happening? Why is this with students with disabilities? Again, We also have a very, very disproportionate use of seclusion and restraints among students of color. So particularly our Black students, particularly Black boys, for some reason, we continue to disproportionately use seclusion and restraint with those students. And again, there's a lot of analysis that has to happen behind that, a lot of soul searching, a lot of discussion that has to occur at, again, the district level, at the school level, at the individual student level, to figure out why this is happening and why has this been the case. And I will say that there's a lot of schools out there that are doing some really, really, really cool, just thorough, unique work to look at their own data and to try to figure out what the heck is going on here and how can we improve the data. And it's really heartening to hear from some of those schools and the successes that they're having. So there are efforts being made out there, and there will continue to be more. The vast majority of incidents, like, I mean, 80-20 or even 90-10, the vast majority of incidents occur at elementary schools, which is, again, something that it invites questions when you hear that. Why is that? Why should that be? Shouldn't it be? I mean, there's a lot of, again, individual questions, but the great majority of incidents occur at elementary schools. And that we've seen, I mean, that was very consistent for the years of data we have. I don't anticipate that will look different now that we're going to get a full school year's worth of data. So the pandemic years and school closures are going to be different years, and we just do not know what the 21-22 data will look like. It's going to be interesting. I don't know. I mean, I won't say I'm looking forward to it, because again, I think, again, we know that this is happening too much in schools, and we know that we need to reduce it. And so, to get the report at all is a little bit, it's not ideal. So I can't really say I'm looking forward to it, but I can say that it's information that we need and that we will look at and use it to make some decisions, both at the DPI level and then really to help districts make decisions at their district level, school level, individual student level, to try to do better in supporting the behavior needs of kids in more supportive, positive ways. So. All right, so that's the end of my presentation. Here are some contacts for if you have questions. The DPI special education team, that number there's also an 800 number that I can get you if you need it. That link that's there will take you to a contact page where you can fill out a form that will put you in touch with someone from the department. We, again, I'd love to say that, our answers come fast, but they don't always. We do our best to get back to people as quickly as we can. We definitely encourage folks to contact us if they've got questions. It's just know that it may take a little bit for us to get back to you, but we certainly will get back to anybody who has some questions. And if anybody has questions now, that's a wonderful opportunity to ask them. I'm here and available. So Bonnie, I don't
Thank
know
you,
if you've been
Raj.
paying attention. Yeah.
Yes, thank you very much. So we do have some questions for you. The first one is sort of like a scenario, and it says, please advise, here's a scenario, and it says, so a student becomes unsafe and the staff restrains the student. The entire episode or incident occurs over a 45-minute period, and the staff had to resume into a physical intervention at least 3 times during the entire episode. All 3 physical restraints are recorded on one incident report. Is this reported as one incident, or should it be reported as 3 separate incidents
Okay,
of
good question.
intervention?
Good question. So under the law, the way that would be considered one incident and reported as such. But I think it's really important to make sure that within that documentation, there's a good description of what actually happened. So it's not 3 separate incidents; it's all one incident. If it was immediate, and when I say immediate, it really means immediate. If the entire duration of the situation was 45 minutes, that's fine. If it was 15 minutes in the morning and then things were cool for a while and then we had another 20-minute incident in the afternoon, those would be separate incidents. But the way that that was described to me as one incident and would be reported as such.
Okay, thank you. And then we have another one. Will there be a further breakdown of incidents involving students with disabilities for reporting purposes?
I guess what I will say to that is that the way that the law requires the data to be reported right now does it doesn't break it down further. So for example, we don't ask, and the law doesn't, I don't know, require us to ask whether the students were students who are identified under different areas of disability or, anything like that. I mean, it's by school, it's by students with disabilities or without, but we don't have a further breakdown of that. That doesn't mean that schools don't have that information, nor that they shouldn't be looking at that information, because I think that's a really telling piece of information. And again, I know that there are districts out there that have done a really good job looking at their data and asking just those kind of questions. Who are we secluding and restraining? What are the characteristics? What are we doing? What can we do differently? So while that data won't come necessarily from DPI under the current iteration of the law, it's a really excellent question. So I appreciate whoever asked that. I hope I got it right. If I missed it, just let me know.
Okay, thank you. And then here's another one for you. Are all schools required to have a seclusion room available?
Oh, great question. Great question. And the answer to that is definitely not. Definitely not. There are lots of schools out there that don't have seclusion rooms. Well, so what does that mean? Well, if you don't have a seclusion room, if there's another safe space where seclusion could be used, that's one thing. But again, it's important for any space that is used for seclusion to be safe. So if, I guess what I'm trying to get at is there's no requirement. Nowhere is there a requirement that every school have one. There's lots of schools that don't. There's lots of schools that don't use seclusion at all. There are circumstances where other types of spaces might be used for seclusion, rooms that are used maybe for other purposes. But if they're used for other purposes, again, it's really important that those rooms be safe. And if you're going to use them for seclusion, they have to be cleared of things that could injure the student, and they can't lock. No locks on the doors. So no, it's not required. There are lots of schools in the state of Wisconsin that don't have them at all. And either they handle behaviors in other ways, or I have a lot of ideas about that, but there is no such requirement.
Okay, thank you. Our next one says, how should schools document elopement incidents? And this is as a result of being secluded or not being secluded.
Okay, elopement is a really, it's a tough one. It's a behavior that, really requires a lot of thinking individually about what's going on with that student. So elopement, for those who don't know, you'll hear people say things like, oh, that student runs, or that student, he'll leave the classroom. That's elopement, when they will, leave the area from where they are and go elsewhere. Elopement's a tough behavior because there are times that elopement is going to potentially create a circumstance that involves risk to the student, and then there's other times not, right? So that FBA process that I talked about before is so crucial in any behavior, understanding any behavior, but certainly elopement. When someone's leaving something and going towards something, are they going away from something? Are they going towards something else? Do they need to move? Do they need to, again, there's lots of reasons. I mean, whether the person needs proprioceptive input. I mean, again, there's lots of reasons that this could happen. And it's so crucial that folks take a good look at that. And, does the student understand what's going on inside the classroom so that they know why they should stay? I mean, again, there's all these kind of questions. An incident of elopement is definitely something that, for purposes of monitoring behavior interventions in general, monitoring what's going on for a particular student, certainly you'd want to document and keep track of them. Elopement in and of itself isn't required to be reported under this particular law. Now, if restraint is used to prevent a student's elopement, then that would need to be reported. If seclusion is used to prevent a student's elopement, that would need to be recorded. But it's important to keep in mind that that's only okay if the student's behavior presents that imminent risk to the safety of the student or others. You know, sometimes we don't know where a student's going to go. I mean, we need to be very careful and monitor students who have this kind of behavior, so we make sure that they're safe, because we do need to keep students safe. But purely to avoid elopement, it's probably not reasonable in many cases to say, well, okay, the student's trying to leave the classroom, we better restrain them. That's kind of a leap. I mean, we need to understand what's going on with students and behaviors. And I know that that's a tough behavior. I know it really, it happens often, and you know, it's one of those ones where we need to put our thinking hats on and really come up with a theory as to why that's happening with that student and what we can do to, you know, support behavioral change in the student in a positive
Okay,
way.
thank you. Our next one is, how do you know crisis teams have met to debrief after a certain incident?
Yeah, that's a good question. How do you know? Well, again, I would say that a lot of people on a lot of districts on the forms that they use to document, and a lot of times these forms are built into their student information systems. A lot of times they'll document whether the debrief happens. I mean, really, it's not something that we collect independently. However, if we get a complaint around seclusion and restraint, and we certainly do still get IDEA complaints every year around the use of seclusion and restraint, if we get those, we will check, and you know, we'll investigate. We'll look at the documentation. We'll interview people who were around and involved. We do check to make sure that the debrief has happened. You know, in a lot of cases, we're relying on, you know, school staff to want to do the right thing and follow the law, which I think the vast majority of folks do. I really 100% believe that people really want to do the right thing. And you know, there might be incidences or certain circumstances where that doesn't happen, but I really do think people want to do the right thing. So if they know they need to do it, it should be happening. And again, it's valuable. It's exceedingly valuable for helping to think about how we might support the student in a different way, and it's supportive of staff, because that's hard. That can be a very tough situation. I've been there. I know it's traumatic for all involved.
So I guess that moves to one of the other questions about, how do you feel about the fidelity of the reporting by schools in general?
Oh boy, that's a really good question, and that can go a lot of different ways, I think. Um, I feel as though this is going to be a real cagey DPI kind of response. You guys are going to love this. Um, but what I feel like is, I think it's new still. It's still new. We are coming off of some very odd years, and so this isn't routine yet. Folks aren't used to it yet. In terms of, you know, what do we do with the data? Um, the law doesn't have a lot of requirements, or doesn't actually tell DPI what we're supposed to do with the data. We do review it, we do look at it, and when we see kind of outliers, maybe it's a school or a district that, you know, things are really, boy, there's a lot going on at this one. We do look into that and check that. And we've done kind of general supervisory activities with those schools to help them reduce, or help them connect with kind of what they might need to get those numbers down. But it's not like we have a process to, you know, validate that data to make sure that it's all being done with fidelity. Again, a lot of it depends on the integrity of folks, and I think that generally folks want to do the right thing, but I certainly can understand, you know, where that question comes from. And anytime there's a new data collection, that's a fair question to always ask, I think. So yeah. In other words, do I think it's necessarily 100% valid and taken with fidelity? I can't say that, and I wouldn't say that. I wish it were. I wish it were.
Okay, thank you for that. I have two more questions and we'll try to fit them in. The
Okay.
first one is, in the debriefing portion, and a teacher is there, a person who had been trained in seclusion and restraint, and it's taking part in the debriefing. Oftentimes, some teachers have asked for union representation
Mm.
during some of these times. What is your feeling on that?
Yeah, I mean, I certainly can understand that. Again, I think that uh, just because of how difficult everything is involved with this, these are not easy situations or we wouldn't be in them, right? Complicated kids with some really, a lot of mental health issues, a lot of different needs, staff that, maybe need different supports than they're getting in their classrooms. I mean, I know it's very complicated. Um, a debrief meeting for the purposes of the law is really only about debriefing the incident. It's not for other purposes. It's not about, again, I think I said this before, but it's not about, who's at fault or who's anything like that. That being said, I can understand how staff may have concerns and might want to have someone with them in order to support them through that if they're worried about, anything at all related to personnel issues or anything like that. I mean, I totally get it. It's what I would say is that it's not, there's no like provision in the law to delay the debriefing to allow for that kind of thing to happen. The debriefing is really, again, separate from any kind of other types of meetings that may result from an incident. This really is for the purpose of talking through the incident and doing the things that the law requires. It's not about, again, who's at fault or, is someone going to have some employment action taken against them or something like that. That's not what the law is there for. But it's understandable. I mean, again, it's understandable. It has to happen though. The debriefing has to happen. And so, I hope folks are approaching it with the kind of attitude that this is about figuring out what's going on. It's not about pointing fingers or assigning blame or anything like that.
Okay, thank you. And our last question so far is, if a student with special needs will not remove themselves from a classroom, would this still be considered seclusion? This particular student is nonverbal and some of the issues can last for several hours.
Okay. So I'd ask more questions in response to that question. First of all, I would wonder if what's happening is actually seclusion. So first of all, is the student being isolated, physically prevented from leaving? That physically prevented from leaving is a really key kind of crucial thing. Sometimes the student might not leave and, maybe the student doesn't want to leave, or maybe the student knows they're not supposed to leave, that kind of thing. That's different from saying, would someone close the door or stand in front and physically prevent that student from leaving? So that's the question, first of all. Is the incident that you're describing, is it actually a seclusion or not? Sometimes it's necessary to, reduce the stimuli in a classroom or an instructional space for the benefit of a student that has real high needs, or sometimes, for safety reasons. There's lots of reasons that could happen. If a student, though, is being isolated, secluded in a place for, several hours at a time, that would be concerning to me, and I would have questions about that. So pretty much in any circumstance like that, I mean, I would say there's lots of questions involved, and there's lots of kind of practice questions that might come into play. Yeah, seclusion generally, when we think about seclusion, it should be in matters of minutes. It should not be matters of, hours, anything like that. It's short, short, short. We know that that's not always the case, but that's really, I think, what the law is envisioning and what the law expects schools to do. So if but there are other things that are not seclusion that might involve, kind of isolation of a student or keeping a student separate, but that doesn't mean that they are physically prevented from leaving. I know that that's tricky and not much of an answer. So if anybody wants to follow up with me, please do.
Well, thank you. I know we're running over time right now. Marge, do you have any closing thoughts that you'd like to share?
Just to thank everybody for your great questions and your attention. And this is continuing to be an issue that we need to work on in our schools in general. Um, I really think that, there's a lot of, it's been a very tough, tough, tough couple of years for schools. We're in tough years for students. And I'm so appreciative of the work that's going on by so many people in schools, by students, and just the commitment to making positive learning environments where things like this don't happen. It's, again, it's complicated right now, certainly, but educators, I know you're working your tails off, so I really appreciate everything you're doing, and I hope that questions can get answered. I hope that you feel supported. I hope that students are feeling supported, and that the school year is cruising along, and that as we roll into the holidays here, that everybody gets a chance to take a very, very well-deserved break. Thank you all.
Thank you, Marge, very much. We really appreciate your presentation today. I know that everybody in participation today has learned a lot from it, so thank you again.
You're
This
welcome.
will conclude our webinar. We'd like to thank everyone for joining us today. Please be reminded that Wisconsin Facets has over 100 trainings and webinars, and you'll be seeing our trainings posted for the year 2023 shortly. Please check out our website calendar and register for any of those upcoming trainings that may be of interest to you. And please watch for the short evaluation that will be coming your way after today's live presentation. Again, thank you, Marge, and thank you everybody for joining us today. Bye-bye, everybody.
Bye.